This is AM 650's The Law Show with Sterling Fox. Now back to the show.
Welcome back. Good to have you with us. We have a group in studio from the Vancouver and Langley law firm, Lindsay Kenny LLP. Angela Thiel and Christine Eilers are with the Vancouver office. Puneet Kara joins us from the Langley office. We're talking family law on this edition of The Law Show. And specifically, we're talking about going to court. That's the thing that is the most dramatic and exciting part of the law from the spectator. Mm-hmm. And at the same time, Angela's always already told us that from the lawyer's perspective, not as much fun as it might look to be from the outside because of the unpredictability of it all. Who knows what that witness is going to say, no matter how well trained up he or she may be. So but what I wanted to find out about, though, is so far, in terms of reasons for going to court, and we've identified either in British Columbia, provincial or Supreme Court. Those are the two places we start an action in a family dispute. But so far, all I've heard are, well, the reasons are because maybe real estate or inheritances, or so far I've heard about money as reasons for court actions. And I understand that part. But what about kids? Where do kids become involved in the court process? When does a person, Puneet, go to the courts specifically requesting something to do with the children?
Yeah, you're looking, when you're looking for something specifically with respect to children, you're talking about how are you going to divvy up the parenting responsibilities, where the child is going to be residing, whether there's going to be child support paid for the child, and if there are more serious issues on the table, that needs to go to court. For example, issues with respect to child abuse,
right,
or child alienation, or things which need to be brought to a judge, because if that's what's happening, a party is never going to admit, and that issue can never be resolved through negotiation.
Right.
It will have to go to court to get protective orders in place, and also to get proper living arrangements, so that you're looking at the best interest of the children from an objective standpoint and not from an emotional standpoint, which parents are quite emotional about.
Of course.
Yeah.
Of course.
So I think...
So would you go to a Supreme Court or provincial court if you have a child-specific action you want to commence?
Both.
Okay.
Both provincial and Supreme Court. Obviously, the factors, like I said, the geographical, the cost, whether we need specific disclosures and we need special enforcements of the orders, that will determine which court to go, Supreme or provincial. But to start with, you can go to either one of those courts. However, for child protection hearings, that is exclusively in the jurisdiction of the provincial court.
Oh.
So
Okay.
ministry, for example, there is child protection concerns and ministry is involved, that has to go in the provincial court, that cannot go into the Supreme Court. So that probably is the exclusive jurisdiction for provincial.
One thing is that I think if you have children, a child-type dispute happening, if there are also property issues that are going to be dealt with down the road,
next question. Way to go, Christine.
then you may just choose to go to Supreme Court anyways, because eventually you're going to need to be there.
Because you've got a bundle. You've got money issues, child issues, and so you don't separate them out necessarily.
No.
You put it together as a package. Now, would that be for economic reasons, just to kind of trying to keep your costs under control?
Yeah, I mean, it's difficult to have one proceeding in provincial court and one proceeding in Supreme Court and have parallel things going on throughout. And it is possible to deal with, the children issues in provincial court and deal with the property issues in Supreme Court, but it's just not very practical.
Okay.
And sometimes you've settled all of your issues. You've already had a separation agreement, and something happens like you think your husband's income or your ex-husband's income has gone up significantly. Sometimes we leave our agreements so that the children and the child support issues can be taken independently to provincial court, a couple of years later. Because
so if there's suddenly more money at play, then it's reasonable that the courts could order more money to be paid to the children.
Yeah.
Well, it's if you leave that under Supreme Court jurisdiction, you're having a divorce, you do a divorce order with child support provisions, you got to go back to the Supreme Court.
Okay.
But you can make a deal that says, well, we're going to get our divorce, but we're going to leave a separation agreement here, and then we can choose to go to provincial or Supreme Court later. And the reason you would go to provincial court is that it's a lot cheaper and you can do it yourself.
Okay.
So if you think, well, I think his income's gone up $50,000, which, is a fairly a substantial amount for a lot of people, but it's probably only $500 a month child support month after month after month. So you don't want to pay your lawyer another $10,000 to go back to the Supreme Court. So I try to do that as much as I can if I'm acting for mom and I see a situation where I think the incomes are going to go up for dad, and give her a way to do it herself.
Okay, and I suppose though what I would like to find out more about is in the distinction you've made, Puneet, between the provincial and the Supreme Court. Let's suppose, not Angela's favorite, but let's suppose I commence an action in provincial court, and I've determined, and I'm getting the eye roll from Christine already. I've determined that I'm going to represent myself. Uh-oh. And there's the old Mark Twain cliche, right? He who represents himself has a fool for a client. I'm aware of all of that, and yet I'm not the richest guy on the planet, so I decide to take the plunge and represent myself. Angela's already said that it's going to be a lot tougher to get an actual date, to get somebody to listen to my side of the story, to have my day in court. Is it more difficult if I choose to represent myself than if I have a lawyer on my team to help organize even the simple basic stuff like getting in front of a judge?
Definitely. A lawyer, again, it really depends upon which stage of litigation you are in. But if a lawyer is involved, obviously you have an objective perspective. You have a lawyer who knows the process. You're not hitting and trying and figuring out on your own as you go along.
Exactly.
You know someone who knows the process,
right,
and is going to do the job for you and put you into the right, sphere of litigation. However, there are many places in provincial court. For example, in provincial court, if you start proceeding by an application, the next step is a first appearance. After all the pleadings, after an application is done, a response is done, and there's something called the first appearance, where you have to go in front of a judge and say, yeah, these are the parties, these are the issues, and whether it's going to go for a next family case conference, which is like a settlement conference with a judge, or a court hearing. Now, that process of a first appearance, I sometimes leave the option for the clients to go and do the first appearance, because there's no point. What happens in a first appearance court, there are 50 other matters in the court that day.
Right, of
so
course.
You're pretty much sitting there and nothing's going to be accomplished.
Right.
So all you have to do that day is to say, unless there's an urgent issue, say, okay, this matter needs to go for a family case conference. I have a lawyer who will be attending the family case conference, consult with the lawyer and get a date. So that job can be done by the self-represented litigant and saving you a lot of money, as opposed to a lawyer going there and spending 3 to 4 hours doing the same job, which you can totally do. So I think it could be a combination of factor as well, even if a lawyer is involved, especially in provincial court, where a certain portion can be done by the litigant himself, and a certain guidance and court process, and when it comes to real law and fighting the issues out, can be done by a lawyer. So I think that benefit is there in provincial court.
I think, Christine, a lot of this whole business about going to court and the process and the protocols involved, this is a really alien environment for most of us. The way things get done, the language that gets used, the terms, the phrases, etc. It's a very strange place for most folks. So if you're in there winging it on your own in this truly alien environment, no matter how many hours you've spent on the internet the night before, you're still in an alien environment in which you are clearly the outsider. So you're not really doing yourself a lot of favors by trying to do this yourself. But why do so many people insist on it nonetheless?
I think primarily it's cost, although there's also those people that think that they know better. They definitely exist, and they choose to be self-represented. They could afford a lawyer, but they'd rather not. There are resources out there. There are, as you say, websites. Some of them are better than others that have self-help type stuff on them. There are duty counsel lawyers that will give some free advice. There are lawyers that will do consultation appointments. So you can get some information for less cost if you need to go to court on your own because you can't afford it. Going to court on your own because you think you know better, that's a really bad idea.
I was just going to say, as soon as you're in there, no matter how smart you think you are, when you're surrounded by that very odd world, suddenly you're a stranger, no matter how smart you may think yourself to be.
And there are the perpetual self-represented litigants, the the people that they read the rules, they continue to sort of serve another court application, usually to reduce child support, hoping that one of these times the woman just won't have the energy to go and fight it. And I say the woman because that is generally a male tactic. And the female tactic is often, that he's asking for access, and she just keeps getting sick, or there's some reason that she can't get to court that day.
Right,
and so,
compliance issues.
Yeah.
Okay.
So unfortunately, the worst of the worst for the judges are the self-represented litigants that are doing it as a tactic.
Yeah.
Mm-hmm.
And it's worse for us as well, as if we happen
sort
to
of
get
the
one of
locker
those.
room lawyer approach, right?
Well, it's I'm going to make it more expensive for my spouse to get what they need. I'm gonna harass my spouse so that they can't parent effectively because they're always spending time responding to my court applications, and I'm going to try to bankrupt them by continuing to try to get a reduction of my child support.
And do the courts have? I suppose they have to entertain the submission. But I would think that there would be some judges who just don't have a lot of patience for that.
There is one rule that is not used often enough, as far as I'm concerned. It's called I think we colloquially call it the Perpetual litigant rule. There's actually a rule that will say to someone, you cannot come back to court again without the leave of the court. And it's for people that, just completely abuse the system. But the judges are reluctant to impose that in a family situation.
Of course,
because, there are kids involved usually.
And and just to add to that context, in terms of proceeding in Supreme Court or provincial court, when you do something like this by a self-represented litigant time and again bringing frivolous litigation into Supreme Court, there's cost consequences, which is not there in provincial court. So that's that if the other side is going to be self-represented and you have a lawyer, you are better off than commencing that proceeding in Supreme Court to some extent, because the other side is going to be, if it's going to be a frivolous application after application, the judge is going to award cost against the other side, which is pretty deterring to the other side to bring on such application in the future. And so,
I mean, unfortunately, the costs aren't usually your real cost that you're paying for your lawyer, but it is a form of deterrence.
The court costs.
Yeah, the court's going to award, you pay your ex-spouse a certain amount of money on account of the fact that you brought this stupid application and then you lost.
And that is in the view of many a judge a pretty frivolous bit of behavior then.
It can be, yeah. I mean,
we need to take a quick break here. We're talking family law with our trio from Lindsay Kenny LLP. By the way, the website is lklaw.ca, and there's all sorts of great information about both the Vancouver and Langley offices. Angela Thiel, Christine Eilers, and Puneet Kara are with us in studio. This is The Law Show on AM 650. More ahead. Stay with us.
There's more of the show still ahead. This is AM 650's The Law Show.